case briefs, and so much more. LSData's got what you're looking for.
In the 1992 case of New York v. United States et al., the Supreme Court of the United States addressed the issue of whether states could be compelled by the federal government to dispose of radioactive waste generated within their borders. The Low-Level Radioactive Waste Policy Amendments Act of 1985 had three provisions that were being challenged, as it concerned the division of power between the state and federal governments, Congress's right to regulate interstate commerce, and whether the act infringed upon state sovereignty. The majority opinion, written by Justice O'Connor, determined that while the Constitution gave Congress the power to encourage states to dispose of their radioactive waste, it did not give Congress the ability to force them to do so. This issue of dealing with low-level radioactive waste had become a problem of public policy, as millions of cubic feet of waste from various sources such as hospitals, research facilities, nuclear power plants, and government agencies required isolation from humans for extended periods of time. The court decided that two provisions of the 1985 Low-Level Radioactive Waste Policy Amendments Act were constitutional, allowing Congress to provide incentives for waste regulation, but it could not force states to implement federal programs. Monetary incentives and the exclusion of waste producers from disposal sites in other states were permissible. However, the take-title provision was deemed unconstitutional. As a result, New York had to fulfill its obligation for low-level radioactive waste facilities, or face liability for failure.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.